Hello, you are very welcome. My name is Manuela Tristão. I'm a lawyer in Brazil, state of Paraná, and member of the International Arbitration Group of the CGA-CBMA. The CGA-CBMA is a young arbitration practitioners in Brazil, and we now have the international branch, which is a new project to expand the CGA-CBMA to international level. And we want to begin this adventure with these VisMoot Talks, which is a project on the VisMoot, because it is a very popular competition and in which many Brazilian universities compete. So we want to broaden our connections and discuss internationally the problems of VisMoot case. So today, we start the first day of the VisMoot Talks. And the panel will cover the main subjects of the procedural issues in the year's VisMoot case, the law applicable to the arbitration agreements. For this, we will have the presence of the speakers, Jessica Beess Und Chrostin, who will start the panel talking about the validity of the arbitration agreement. Afterwards, Marcelo Inglez de Souza will present about the law of the Seat of Arbitration as the law applicable to the arbitration agreement. The third issue will be presented by Soterious Loizou, who will talk about the law of the contract of arbitration as the law applicable to the arbitration agreement. And Dr. Loizou will join us during the event. And then Aleksandrs Fillers will close this panel with the issues concerning the application of the CIST to the arbitration agreement. At the end, we will select some questions from the audience for the speakers to answer. So before passing the floor to Dr. Jessica, I would like to briefly introduce her. Jessica Beess Und Chrostin is a senior associate at King & Spalding in New York, USA, and represents clients in international commercial arbitration, investment treaty arbitration, intra-state arbitration, and international disputes before USA courts. So, Dr. Jessica, feel free to start.
Thank you very much for that introduction, Manuela. First, I would like to say thank you to Manuela and to the organizers of this panel. I'm very happy to be here today, even though it is 7 a.m. in New York. And I'm grateful for the invitation, especially to speak on such an important topic. And I did want to add before I start that I've actually been involved in the Moot, originally as a participant and then as a coach, for a little over a decade now. So this is very near and dear to my heart. And I'm, as I said, very excited to be here. So as most of you, I have no doubt, know, in this year's VisMoot, there is a dispute as to the validity of the arbitration agreement, among other things. The claimant this year argues that the arbitration agreement contained in its general conditions of sale was agreed to between the parties, whereas the respondent argues that the arbitration agreement was not agreed. So there is no valid agreement to arbitrate the dispute in issue in the VisMoot. Now, even beyond the VisMoot specifically, the validity of the arbitration agreement is obviously a key issue in international arbitration. So this is an issue that you will encounter in your day-to-day practice on a regular basis. Without a valid agreement to arbitrate, no tribunal or arbitrator can have jurisdiction over a dispute because arbitration is fundamentally a creature of consent. Without consent, there is no arbitration, and certainly no valid and enforceable arbitral award, which is the end goal of an arbitration. Now, on the facts of this year's case, there are 3, arguably 4 international instruments that are relevant to an analysis of whether the arbitration agreement in issue in the VisMoot was valid. These are, first the Unidoc Principles, and they are relevant because the contract law of 3 of the 4 fictional jurisdictions in issue in the VIS problem is a verbatim adoption of the Unidoc Principles. The second instrument is the Ansitrol Model Law, and this is important because the national arbitration law of all 4 jurisdictions, that's Danubia, Equatoriana, Mediterraneo, and Ruritania, is a verbatim adoption of the model law. And the third instrument, which I will be addressing today, is the New York Convention. And this is relevant because all 4 countries are member states of the New York Convention on the enforcement of arbitral awards. The fourth instrument that is arguably relevant, depending on which side of the arbitration you're on, is of course the CISG. I will not be addressing the CISG to avoid overlap with Aleksandrs Fillers' presentation later on. Before I dive into the substance of the relevant provisions of these instruments, I do want to preface this presentation by saying that I cannot give you the arguments to present in the moot, of course, because the moot is ongoing. So I will focus my remarks on discussing the relevant frameworks and the legal instruments, and you can take this discussion and incorporate any important points or relevant points that you deem fit into your arguments in the competition as you progress. So with that, I will start with the Unidoc Principles. The Unidoc Principles on international commercial contracts are a set of over 200 rules for international contracts. They were first drawn up in the 1980s, and they have since been revised by an international working group of the intergovernmental organization Unidoc. And there are several provisions of the Unidoc Principles that are potentially relevant to this year's VisMoot problem. I don't want to make this presentation too dry, but I ask that you bear with me as we walk through each, as they are relevant to your analysis. So the Unidoc Principles tend to focus on substance over form. Thus, in Article 1.2 of the Principles, it states that, quote, nothing in these principles requires a contract, statement, or any other act to be made in or evidenced by a particular form. It may be proved by any means, including witnesses. This is an important distinction from some of the other relevant international instruments that we will discuss later. The Unidoc Principles are concerned with, as I said before, the substance or the material validity of the arbitration agreement, and not so much the formal validity. And to determine whether an agreement to arbitrate, or actually any agreement under the Unidoc Principles, was validly entered into, we must look to the substantive requirements for validity that are commonly applied to any type of contract, not just arbitration agreements. So the same principles apply whether you're dealing with an arbitration agreement or with another type of contractual agreement. For purposes of the VisMoot specifically, as I mentioned earlier, there are several provisions of the Unidoc Principles that govern contract formation and that could be relevant. And the starting point here is really Article 2. It addresses offer and acceptance of a contract. Article 2.1.1 governs the manner of formation, and it provides that, quote, a contract may be concluded either by the acceptance of an offer or by conduct of the parties that is sufficient to show agreement. So the relevant inquiry here is, again, it goes to the substance over form. And you need to look at the VIS problem and identify what evidence you can muster to show acceptance of an offer by conduct, given that Ms. Bupati, the representative of the respondent who was engaged in the negotiations over the contract and issue in the dispute, never returned a signed copy of the contract. So here you might want to look at any email communications, any oral communications, any follow-up regarding the contract, discussions about letters of credit, things like that. Then you should probably, up to you of course, but I would recommend moving on to Article 2.1.6, which is also relevant here as it governs the mode of acceptance. And subclause 1 of Article 2.1.6 provides that a statement made by or other conduct of the offeree indicating assent to an offer is acceptance. But importantly, it also contains a qualification. And it says that, quoting again, silence or inactivity does not in itself amount to acceptance. This is obviously a relevant provision given that, as I just said, respondent's representative never returned a signed contract to the claimant. But that's not the end of the inquiry. You also need to look at the third subclause of Article 2.1.6 and at the official commentary on the Unidoc Principles, all of which can be found publicly online and which you've probably already found at this point in the competition. So subclause 3 provides that if by virtue of the offer or as a result of practices which the parties have established between themselves or of usage, the offeree may indicate assent by performing an act without notice to the offeror, the acceptance is effective when the act is performed. And the official commentary explains that the situation, namely silence is not acceptance, is different. It's different if the parties themselves agree that silence shall amount to acceptance, or if there exists a course of dealing or usage to that effect. For purposes of the moot problem, you want to explore whether there are practices or usage between the parties that are relevant in this context. As you probably know, on several, I believe it was 5 prior occasions, Ms. Bupati did not respond to a draft contract, but still considered it binding and performed under that contract. But at the same time, when those 5 contracts were performed, she did not work for the respondent company. She worked for the parent company. And so the question is, does this impact the analysis of usage between the parties? Does it matter whether Ms. Bupati was working at that time for the parent company versus the respondent here? And another relevant provision that you may want to take a look at is Article 2.1.19. This provision is relevant because it governs contracting under standard terms. Because the arbitration clause at issue in this case is contained in the general conditions of sale of the claimant, this becomes a relevant provision. And subclause 1 of Article 2.1.19 provides that where one party or both parties use standard terms in concluding a contract, the general rules on formation apply, subject to Articles 2.1.20 through 22. And subclause 2 states that standard terms are provisions prepared in advance for general and repeated use by one party and which are contractually used without negotiation with the other party. I think it is undisputed in this case that claimant's general conditions of sale are standard terms. So this is not a provision that should warrant too much attention in your analysis, but it would still be helpful to note at the outset that this is an undisputed agreement between the parties, one of the few undisputed points. But again, I mean, the inquiry still does not end there. Article 2.1.19.1, as I just told you, it provides that the general rules of contract formation apply subject to subclauses 20 through 22. So you need to look at those. And to save time, I'll just point out that Article 2.1.20 is probably the most relevant here. And it provides that no term contained in standard terms, which is of such a character that the other party could not reasonably have expected it, is effective unless it has been expressly accepted by that party. And it further provides that in determining whether a term is of such a character, regard shall be had to its content, language, and presentation. So the question you need to be addressing in your presentations, in your arguments, in your analysis becomes whether the arbitration clause in the general conditions, in the standard terms, is a clause that requires that special attention be drawn to it. And if it is such a clause, you need to analyze whether that was done sufficiently here, having regard to the content, language, and presentation of the clause. And in the context of this assessment, you may want to consider the oral negotiations between the parties, any discussions specifically about arbitration are relevant here, the presentation of the arbitration clause, and the cover note that drew attention to the arbitration clause, among several other facts, of course. So this, in a nutshell, is the analysis that you should be considering concerning the substantive validity of the arbitration agreement. But the next step of this analysis concerns the formal validity of the arbitration agreement. And here we will look primarily, not exclusively, but primarily to the Ansitrol Model Law. The Ansitrol Model Law on International Commercial Arbitration is a model law prepared by the United Nations Commission on International Trade Law. And it was adopted by Ansitrol back in the 1980s. So similar timing as the Unidoc Principles. The Ansitrol Model Law was amended in 2006. And for purposes of the VisMoot, you want to be looking at the more modern version of the model law. And I'm sure I'm not breaking any news here when I point out that the most relevant provision of the Ansitrol Model Law for purposes of the VisMoot problem this year is Article 7. The model law, if you read it carefully, it actually offers states two options that parties can choose from for Article 7. The first option is a lot more detailed than the second option. And here, the problem specifies that Danubia has adopted option 1, the more detailed option of Article 7. So I will focus on this one for purposes of my discussion. So option 1 imposes a form requirement on the parties for a valid agreement. Under subclause 1, an arbitration agreement may be in the form of an an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. This means that the arbitration agreement need not necessarily be contained in the main contract between the parties. This is obviously relevant here where the arbitration agreement is not contained in the main contract between the parties, but rather in the conditions of sale of the claimant. Subclause 2 of Article 7 requires that wherever the arbitration clause is, it must be in writing. But what constitutes a writing for purposes of the Ansitrol Model Law is explained in subclauses 3 and 4 of Article 7. Under subclause 3, an arbitration agreement is in writing if its contents is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally or by conduct or by other means. This is quite broad, actually, if you look at a form requirement. Any form will suffice, whether a contract is concluded orally, by conduct, or by other means. And then in subclause 4, we learn that a writing is also defined very broadly, and it includes an electronic communication if the information contained therein is accessible. Accessible is a key word here. It doesn't have to be necessarily provided, depending on case law, but it has to be accessible so as to be usable for subsequent reference. And this includes electronic data exchanges, emails, telegrams, telexes, telecopies, and so forth. Some of the language, some of the options here are a little bit outdated, but case law has applied these terms more broadly to present-day communications as well, including emails and so forth. So again, we're looking here at a form requirement, but it is a very broad definition of what a writing consists of here. And finally, under the model law, you may also want to look at Article 7.6. And this provision states that the reference in a contract to any document containing an arbitration clause constitutes an arbitration agreement in writing, provided that the reference is such as to make that clause part of the contract. So that's really the point that you'll be debating in this year's VisMoot when you're talking about the model law. So just to conclude briefly on the model law, the form requirement is there and you need to engage with both the substantive element and the form requirement in the model law, but it is not particularly stringent. It's actually quite broad. And this brings us to the third instrument that I will be discussing today, which is the New York Convention. The New York Convention was adopted back in 1959. So it was actually the earliest of these three international instruments, and it has since been ratified by over 160 countries worldwide. And I just want to pause here for a second because I think that even aside from the VisMoot, it's important to point out that the New York Convention is probably the international agreement, if you focus on international arbitration in your practice, that you will encounter most frequently. At least in my practice, that has been the case. We regularly have cases that arise under the New York Convention, or at the very least that involve considerations that are presented in the New York Convention as to the circumstances in which an arbitration agreement and a resulting award may be validly enforced in countries across the world. So this really is a convention that you will probably encounter frequently in your careers if you pursue international arbitration. And the New York Convention is slightly different from the Unidoc Principles and the Ansitrol Model Law because its full title is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So that is precisely what the convention is. It does not set forth, unlike the model law and the Unidoc Principles, a comprehensive set of rules that govern contract formation, performance by the parties, etc. It really is concerned with the circumstances under which an arbitration agreement was validly entered into, such that a resulting award can be enforced. So it really directs courts considering applications to enforce arbitration awards to consider precisely the issues that are presented in this year's VisMoot, namely, whether an agreement to arbitrate was validly entered into. So here, one more point with that regards practice before I dive into the substance again. When you're thinking about the New York Convention, one of the reasons this is such an important convention for your future practices is that if you are a client pursuing arbitration, you want the resulting award to be enforceable, or else it is no more valuable than the paper on which it is written. So again, this is a critical convention. I would urge you to pay very close attention to it. So now returning back to the context of the moot, here, Article 2 of the New York Convention is particularly relevant. It lists certain criteria for a valid arbitration agreement and provides that if these criteria are met, a court in a contracting state shall recognize an agreement to arbitrate. And that is mandatory language, shall recognize. So Article 2 addresses some form requirements and some substantive requirements. It lists 3 criteria. The first is that the agreement must be in writing. This, of course, is a familiar condition. We just discussed it in the context of the model law. And like the model law, writing under the New York Convention has also been broadly defined. For example, in Article 2 itself, there is a definition of writing, and it provides that, and I'm quoting now, the term agreement in writing shall include an arbitration clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. Here again, the language is a little bit outdated, but courts have interpreted this to also include present-day forms of communication that are electronic, so not just strictly speaking letters or telegrams. The second requirement under Article 2 is that the arbitration agreement must deal with, quote, any existing or future disputes in connection with a defined legal relationship, whether contractual or not. In the context of the VIS problem, of course, there is an alleged contractual relationship. So this second criteria is not really an issue. And the third criteria is that the arbitration agreement must concern a matter capable of settlement by arbitration. This goes to something called the arbitrability of a dispute, and it's not an issue in this year's moot problem. Although it has been in the past, so it might come up in future moots again. In addition to Article 2's form and substance requirements, other provisions of the New York Convention set forth additional substantive requirements, one of which in particular may be relevant to this year's VisMoot problem. Several are not, but this one I think might be. In Article 5A, the Convention provides that recognition and enforcement may be denied if, among other things, the arbitration agreement, quote, is not valid under the law to which the parties have subjected it, or, failing any indication thereon, under the law of the country where the award was made. Put differently, this means that recognition and enforcement of an award may be denied, not mandatory language, this is discretionary, but may be denied, if the arbitration agreement was invalid under the law of the seat of the arbitration. And I'm quite sure you've analyzed this provision extensively in your written submissions in the VisMoot this year. And I actually believe this might be a natural segue for our next presentation. So I'll just conclude by saying thank you again very much for the opportunity to speak today, and thank you for your attention to the presentation.
Dr. Jessica, thank you very much for the explanation. It was extremely clear. Thank you very, very much. And now moving on to the next issue that will be presented by Dr. Marcelo, who is a partner in the areas of civil litigation, arbitration, and intellectual property at Demarest Lawyers, Brazil. Dr. Marcelo, feel free to start.
Well, thank you so much for the invitation, for the kind introduction. It's a pleasure to be with you all here. Jessica, congratulations on the presentation. Very clear, very instructing. My topic here is about law of the Seat of Arbitration as the law applicable to the arbitration agreement. And just like Jessica suggested, I don't want to jump into the merits of the moot questions and themes, so that we don't go further than we should here. So my idea would be obviously to talk here abstractly about how you analyze that, and most importantly, I think also bringing you guys a practical and approach of how to deal with this matter in real life. I think at the end of the day, the purpose of moot is to prepare lawyers for future arbitration proceedings, and then the question is, how do you really apply that in real life when you are in a dispute? So moving on into the topic, when we talk about the seat of arbitration, the law of the seat of arbitration as the law applicable to the arbitration agreement, first of all, we have to step back and make a important separation of the topics, right? So when we talk about the doctrine of separability, considering the fact that the arbitration agreement is held as an agreement separate from the main agreement per se. So that is the first important analysis to be made. You have to consider the difference between the main agreement on the subjective analysis and the substantial analysis of the merits and the agreement between the parts, and the arbitration agreement as an agreement destined to work solely on the rules for a potential dispute and arbitration. So when we talk about doctrine of separability, it's a conception and practical cornerstone of international arbitration. It means in practice that arbitration clause is a contract and is considered to be a separate contract from the main agreement, and that should survive in case of any termination, invalidity, or dispute over the main agreement. Thus, the separability ensures that when the party claims that there has been a total breach of the contract or the contract is null, still the arbitration agreement would prevail. In other words, that agreement, the contract per se, is not destroyed for all purposes. It still survives, at least for the sake of ruling the arbitration proceeding, and therefore how the dispute over said contract should be regulated. In this regard, we must obviously remark the fact that when we talk about the doctrine of separability, there is a restricted view over that and also a broader view over that. So under the perspective of a restricted view, the purpose of separating the main agreement from the arbitration agreement is simply to safeguard arbitration tribunal jurisdiction for the enforcement of a dispute resolution or for the analysis and of this arbitration proceeding and agreement. So that would be the sole objective of having the separability of the main agreement to the arbitration agreement, simply to make sure that no dispute over the main agreement affects the validity of the arbitration agreement. Okay, but that's not the only perspective you have over the arbitration agreement separability. I mean, there is another part of doctrine which says that the separability means that the arbitration agreement can be governed by different national law from the one applicable to the main agreement. So more than just separating the main agreement from the arbitration agreement for the purpose of keeping the arbitration agreement alive in case of a breach or invalidity of the main agreement, the separability would also allow you to choose different laws for each of the agreements. So you may choose one specific law for the main agreement and another specific law for the arbitration agreement. And by doing so, the separability doctrine would allow you to have those two different laws living along in the same context, each of them with the target of ruling and governing one specific agreement. Well, the question then is, what should prevail? How we do that in practice? Okay, as I said, my suggestion, my contribution here would be to provide you with a practical approach over that. And in practice, we must say that usually the parties are very engaged in always providing for a specific law for the substantive contract. So in practice, it's very usual to see the parties ruling the agreement, providing in main agreements the law of the main agreement, and by doing so, assuming, let's say, taking an assumption that such law would also govern the arbitration agreement, the arbitration clause inserted to that agreement. Okay. Most of the cases, if there is no specific provision about the law applicable specifically to the arbitration agreement, that would mean that the parties intended that the whole relationship be governed by the same system of law. And in case you appoint one specific law for the main agreement, that would be taken as the one also applicable to the arbitration agreement. It's actually unusual for you to see someone choosing one specific law for the governance of the arbitration agreement separately from the main agreement. However, we must say that, on the other hand, it's very common to see also the parties providing for the arbitration rules. For instance, those coming from the for any center of arbitration that is chosen for administrating and dealing with any kind of dispute. So the point is, if you can choose the rules of arbitration according, for instance, if you are in an ad hoc arbitration, you can even set those rules provided that they are valid under, in case of a dispute under the Seat of Arbitration, or where you want to enforce such arbitration award, but let's not step so further. But anyway, when we talk about the rules of a center of arbitration, you're already providing rules for the arbitration agreement. So if you do so, the question is, can you also choose the law that would govern that, more than the rules for the arbitration, but the law that would ground such rules and that would be applicable at the end in case of enforcement, in case of a dispute over the validity of such arbitration decision. So then the question is, how do you deal with that situation if you have an express agreement, express provision talking about the substantive law applicable to the main agreement, but you don't have specific provision talking about the law applicable to the arbitration agreement? The question is how you deal with such situation. No doubt that if there is express provision talking about the law applicable to the arbitration agreement, that should be accepted and taken as valid to the limits of the law of the Seat of Arbitration, because obviously when you are at the Seat of Arbitration, you would have some mandatory law that would prevail over any other law chosen by the parties. But in principle, taking for granted that the chosen law for the arbitration agreement is not in conflict with this law of the Seat of Arbitration, you can choose the law applicable to the Seat of to the arbitration agreement. So no doubt about that, as much as you can choose also the arbitration rules that are usually attached to the center of arbitration that you choose. But as I said, this is not so common. It's not something that usually happens. Most of the times you see the provision about the substantive law to the main agreement, but you don't see a provision specifically for the arbitration agreement and the procedural rules for the arbitration agreement in that sense. So in that, well, that is a big point of dispute. It still remains as that. But the fact is that there has been a lot of discussion around this theme, this topic, and perhaps the most important case that dealt with this situation is the case involving SulAmérica Energias Renováveis. Coincidentally, a precedent coming involving Brazil, where I come from. Basically a dispute over insurance company and insurance party, and then there was a dispute of a provision involving a Brazilian jurisdiction, stating that Brazilian law should apply, and the courts of Brazil would be entitled to rule over disputes. But then there was also a mediation clause and an arbitration clause. And this arbitration clause subject to the seat of taking London as the seat of arbitration. And then there were, I mean, to make a long story short, there were anti-suit disputes in Brazil and in London as well, disputing which one should prevail. But the question is, what would be in that case the applicable law for the arbitration agreement? And on one hand, we had one of the parties supporting the fact that if the substantive law was the Brazilian law for the main agreement, and there was no different provision to that in the agreement, then Brazilian law should prevail for all facts. But on the other hand, you also had an arbitration clause having the seat of arbitration as London. And arguments supporting the fact that if the parties chose London as the seat of arbitration, then most probably they expected the British law London law to apply for ruling the arbitration agreement? Well, the idea here is not to go into the details of this case, but the fact is that as of this case, we came to what we call today this idea was developed as of this case, the idea of the three criteria for determining the proper law for the arbitration agreement. So basically, what would be the strategy, the approach for you to determine the law applicable to an arbitration agreement in case there is doubt around that? So obviously, the first approach, talking about this criteria would be the express choice. As I said before, if there is an express choice talking arbitration about the law applicable to the arbitration agreement more than the one applicable to the main agreement, then obviously this law is to prevail, provided that such law is not in conflict with the seat of the law applicable to the seat of arbitration. At the end of the day, you must make sure that the seat of arbitration law is respected and fulfilled. Otherwise, you will have a cause of nullity under the seat of arbitration. But if there is an express choice, then obviously this express choice for the arbitration, for law to the arbitration agreement should prevail. Second approach would be the so-called implied choice, which is a case in which there is no specific provision talking about the law applicable to the arbitration agreement, but there is, in the context of the agreement, the main agreement and the arbitration agreement, you can realize that the parties implied chose to one specific law, which, by the way, was a lot of the discussion around this Sul America case, because you start to interpret how the choice of the law applicable to the main agreement was made, and also the provisions of the agreement, how you select all that, the context in which the provision is taken. And at the end of the day, if you can imply that in spite of the absence of a specific clause, the parties have chosen to one specific law, or for instance, the arbitration, the law applicable to the main agreement as the arbitration, the law applicable to the arbitration agreement. In that case, you accept, the doctrine accepts that the fact that there was implied choice, and that choice should prevail. This second approach is very close, goes together, and is bound and related to the third approach, which is looking into the law that closest and most really connects to the case, and obviously to the whole context of the dispute. So apart from what would be an implied choice, you should also look into what's the real connection, what should be the real connection here. And in the case involving Sul America, for instance, there was a big dispute around that, because the dispute involved a power plant, the insurance over a power plant in Brazil, and facts that took place in Brazil. Parties were Brazilians. So at the end of the day, you have a lot of connections pointing out to the Brazilian law. And therefore, this type of analysis should take that connections in consideration. Interesting to say that in spite of that, in that specific case, Brazilian law did not, in Brazil, Brazilian law prevailed for the sake of for the law applicable to the arbitration agreement. But in London, the decision was that the London law should apply, specifically because there was a choice for the seat of arbitration as being London. And if the parties, in spite of being Brazilian, in spite of disputing over a Brazilian power plant in Brazil with Brazilian facts, still chose to have the seat of arbitration in London, that meant that the parties somehow implied chose to go through the London law for the arbitration agreement, which is an interesting approach, and because, in fact, what takes you so far for setting the seat of arbitration, if you could do that in Brazil? So there must be a reason behind that. So that's what the court in London did. I mean, why would they come here? And apart from that, there was a dispute over the validity of the enforcement of the arbitration clause without acceptance of one of the parties under Brazilian law. And in London, that would not apply. So the London court took that in consideration as well to give fully enforceability to the arbitration clause. But anyway, the importance here is to be aware of the three criteria when you are to determine the law applicable to arbitration agreement. So you go for the express choice, and then you go for the implied choice, and then you look for the close and most real connections to the case, so that you can, at the end of the day, consider what would be the best choice for the arbitration law. Having said all that, in practice, I think we have to be, if you look into the decisions and obviously the doctrine involved in that discussions, obviously very interesting, very nice to look into that, discuss all the different doctrines applicable to it and so on. But the fact is that we need to be practical. In practice, what happens if you fail to look into the correct law applicable to the agreement, and then you might face a big difficulty in enforcing an arbitration agreement and decision in the future. And that brings us to the fact that when you look at the New York Convention, you will obviously realize that one of the causes of dispute for enforcement of the arbitration agreement is any reference to the fact that the agreement or the arbitration decision was not valid in the place or in the country where the award was made. So the law of the seat of arbitration is very important when we are talking about enforcement. You cannot disregard that. As I said, you can choose the arbitration agreement law, but you must make sure that it is compliant with the mandatory law of the seat of arbitration. Sometimes it's worse for you to try to for one or two specific reasons, choose a different arbitration agreement law, different from the seat of arbitration, and in practice, you will face then some conflict between those two laws, and at the end of the day, the seat of arbitration law will certainly prevail for the validity of the arbitration agreement and for the validity of the arbitration award. So in practice, in spite of being free to choose for the arbitration agreement law, the law of the seat is most of the times the closest and the most real connection to the arbitration agreement. And that should be something to be kept in mind. We talk a lot about having the arbitration agreement or the arbitration clause as the midnight clause, the one that has less attention of the parties. And then suddenly when you face a dispute, you have a big difficulty in enforcing the arbitration agreement, enforcing arbitration award. In practice, you also see people choosing for the seat of arbitration simply because they fear that accepting one specific seat would mean benefiting one of the parties because that party, for instance, has a relation to said seat of arbitration. That is a very narrow analysis because obviously it does count, but it's not the most important thing. Most important thing is to make sure that the arbitration agreement, the arbitration award are valid, and finally, that they can be enforced either at the seat of the arbitration or in a place where you are to enforce it and accept that such place will take said decision as valid because it is valid at the seat of the arbitration. So this discussion involving the law of the arbitration agreement has had many backs and forths in the last years. So you have approach saying that you should only consider differently if you have a specific choice. Then we can quote Sonatrach Petroleum Corporation as a jurisprudence, Svenka Petroleum, and so on. You have a second approach talking much closer to the implied choice, as I mentioned, and then you have Abuja and versus Meridian as one of the cases that are many times quoted. And then you have the three-step approach, as I said, from South America. And to be very honest, there is no final conclusion what should prevail on that. What we can say is that both ways, in common law and in civil law approaches, most of the cases accept the fact that obviously explicit choice should prevail. Obviously, if there is a choice, that choice, express choice should prevail. But in case there is no specific choice, most of the times, the law of the Seat of Arbitration tends to prevail, because you want to make sure that your arbitration agreement is valid and converge to the law of the Seat of Arbitration, so that there is no dispute over the validity of said arbitration agreement and said arbitration award in the future at the time of enforcement under the New York Convention. Finally, it's important to bear in mind that whenever you make such analysis, you need to think about where you intend to enforce the arbitration award. So it doesn't matter how good your arguments are and how applicable your doctrine may be, if the enforcement will take place in a country, in a jurisdiction, where such doctrine or such arguments do not prevail. So at the end of the day, whenever you are to decide over the Seat of Arbitration, and most importantly, the law applicable to the arbitration agreement, you must bear in mind where you intend to enforce such award. That is perhaps the most important thing for your decision, where the arbitration agreement should take place as a seat, and where which law should apply to the arbitration agreement. That is the main driver for you to decide on the law applicable to the arbitration agreement, because at the end of the day is what will bring you in practice the results of the whole arbitration dispute. We say a lot in Brazil, it's not worth to get a very nice arbitration award in your favor if at the end of the day you cannot enforce it. So the question is, where are you going to enforce it? Is the law applicable in that place, accepting your argument, your doctrine? So think about that before choosing the doctrine and the law applicable to your case, because the local courts may not be so in agreement with that. So I don't want to take more time. I just wanted to put those topics on the table so that we can further discuss on that. And thank you all for the attention and time.
Dr. Marcelo, thank you very much for accepting our invitation and for the excellent class. And now moving to the next point, which will present by Dr. Soterious Loizou. And by the way, Dr. Soterious, thank you so much for joining with us today. And I would like to introduce Dr. Soterious, who is a senior lecturer, associate professor in commercial law at King's College in London, and PCO research fellow at the School of Law. Dr. Soterious, whenever you want, the floor is all yours.
Excellent. Thanks a lot. Thanks a lot, Manuela. Good morning, good afternoon, good evening to all. First things first, many thanks for the very kind invitation and congratulations congratulations to the organizing committee of the first CJEA CBMA VisMoot Talk. What a lineup of speakers that you have. What amazing presentations. Thanks a lot, Marcelo, for the excellent presentation or the arbitration agreements that I joined late, and apologies for that. Congratulations to everybody and best of luck in the organization of many more exciting events in the future. Now, over the next few minutes, I will try to offer an overview of the law governing the arbitration agreement and its link to the law governing the commercial contract. Of course, Marcelo covered so many topics and raised so many issues. It is very difficult not to have an overlap over here, but I will try to be as succinct as I can and try to avoid as many points that Marcelo has so eloquently discussed so far. To begin, it is tried that the arbitration agreement is an enforceable promise whereby parties agree to resolve their disputes before a panel of private parties. Although it might manifest in a number of ways. It might be a completely independent document where we have the enshrinement of the arbitration agreement, or it could be a submission agreement that comes ex post. Typically, arbitration agreements manifest as an article, as a clause that we have in the underlying business transaction. It is part of the document of the international business transaction that we're interested in resolving in the event of a dispute. This, however, should not make us forget about the separability doctrine, and that actually the arbitration agreement is separate and distinct from the underlying business transaction. To what extent it is separate and distinct, it is exactly what Marcelo noted about the light or the more rigorous, let's say, the narrow or the broader separability doctrine, the way that we perceive it. And this brings us to the concept of separability or severability of the arbitration agreement and the separability or severability doctrine. Pursuant to this doctrine, again, very succinctly, the arbitration agreement is separate and distinct from the international business transaction at hand, from the underlying matrix commercial transaction. Even when the arbitration agreement takes the form of an article, even if the arbitration agreement is has been embedded as a clause in the matrix contract, it is truly a separate agreement. This is not something unique to arbitration agreements. It is something that we have seen and we will keep seeing in all types of dispute resolution agreements, broadly defined. Choice of law agreements, choice of court agreements, quasi-choice of law agreements. We have seen that in draft regulations of the European Union, the Common European Sales Law, the failed project. Again, we have the separability and the severability doctrine, not only enshrined in conflict of laws, but also in international uniform law instruments such as the draft regulation for the CESL. Anyway, back to our topic. What is the reason for treating arbitration agreements as standalone agreements, as separate and severable? Truth be told, there is no good intellectual reason for doing so. The reason is practical, and it has already been noted. If an allegation of invalidity of the matrix contract were to cross to the power of the tribunal to decide on the merits of the case, then the entire purpose of having a tribunal to resolve disputes pertaining to the underlying transaction would be completely defeated. Under such scenarios, any attack on the matrix contract would cross to the arbitration agreement, not allowing the adjudicatory authority that has been selected by the parties to decide on the merits of the case completely, on whether we have an invalid contract or not. And vice versa, we have this insulation of these two transactions pertaining to the validity. To what extent this applies to the law governing each transaction, each arrangement between the parties, it is a matter of construction, contractual interpretation, and to the extent that we will recognize and apply this doctrine of separability of the dispute resolution clause and the matrix contract. Again, this is not something unique to international commercial arbitration. It is not something unique to arbitration agreements. It pertains to any dispute resolution arrangement between the parties that is distinguished by elements of internationality. Choice of law, choice of court, arbitration agreement, all are distinguished by this separability or severability doctrine. Now, the separability doctrine could have ramifications pertaining to two aspects of the arbitration. That is, firstly, the law governing the arbitration agreement and the law governing, to some extent, the matrix contract, whether it is the same or different. And secondly, the validity of the arbitration agreement and the validity of the matrix contract, respectively. We're focusing only on the law governing the arbitration agreement. We're not going to discuss at all about the validity of the arbitration agreement and issues of invalidity that might arise in practice. Perhaps the directors of the MOOT could think of a problem-based scenario for next years, for the following years on these particular topics. But for our purposes here, let's focus on the law governing the arbitration agreement. How do we determine the law governing the arbitration agreement? We need to go to conflict of laws rules, to private international law rules, private international law and conflict of laws being used interchangeably in this presentation. Now, conflict of laws or private international law rules are those provisions which tell the adjudicatory authority what regime to apply if more than one regime's claim application to the issue at hand. For example, if we have an international sale of goods contract, do we apply the laws of country A, the laws of country B, the laws of a neutral state, an international uniform law instrument such as the CISG? Do we apply a soft law instrument such as the Unidoc Principles, and so on and so forth? This is what conflict of laws rules tell us, and specifically what choice of law rules or conflict of laws rules in a narrow sense tell us. The conflict of laws rules are always found in the lex forum, in the law of the judge, in the law of the forum, in the law of the court. That is always the case, independently of the source of this conflict of laws rules, be it an EU regulation, be it a statute, be it an act, the Swiss Private International Law Act, be it provisions in the Civil Procedure Code, in the Civil Code of the jurisdiction, be it case law, binding precedent. So the conflict of laws rules are always found in the lex fori. Determining the law governing an agreement, including the law governing a dispute resolution clause, such as an arbitration agreement, would be relatively straightforward exercise when it comes to international litigation, simply because there is certainty as to the conflict of laws rules that we have in international litigation. We will go to the sources of conflict of laws rules of the particular jurisdiction where we have our dispute. We will find the relevant conflict of laws rules, and we will apply them in a somewhat mechanical manner and appreciate and reach the conclusion regarding the law governing the arbitration agreement. In stark contrast with international litigation, what conflicts rules are pertinent and how they should be applied in international arbitral proceedings is a topic that remains opaque. Indeed, in the context of international arbitration, conflict of laws questions are multiplied due to a proliferation of concepts and potential connections with multiple regimes, as well as by the introduction of a second layer of conflict of laws inquiries because of the existence of the arbitration agreement. So we have an extra layer. Besides, in arbitral proceedings, in international arbitration, we lack the certainty of elaborate conflict of laws provisions in the various legis arbitri. Go, for instance, to Article 28 of the Ansitrol Model Law. We do not have the clear conflict of laws rules that we have, for instance, in Rome I regulation in the European Union. We do not have the extent. We have a very succinct delineation of what could be the substantive law applicable to the case at hand. Now, in relation to arbitration agreements, the most important conflict of laws inquiries pertain to, firstly, what law determines the capacity of the parties to conclude agreements, and secondly, what law governs the very arbitration agreement. Regarding the capacity of the parties, it is not relevant to what we're discussing here, but just to touch upon it briefly. Regarding the capacity of the parties, most conflicts rules worldwide adopt an approach that ensures the existence of the contract. Usually the conflicts rules will delineate a list of alternative solutions such as the law of the party's nationality, the place of contracting, and so on and so forth, which will be examined to identify a law that validates the existence of capacity to conclude the agreement, to conclude the arbitration agreement at hand. So we have an attempt by conflict of laws rules to ensure that the parties have capacity to form, to conclude this dispute resolution clause. But again, these are private international law issues that are only peripheral to what we're discussing right now. Moving on to the law governing the arbitration agreement, the issue is slightly more complicated. The law applicable to arbitration agreements will, governing the arbitration agreement, will govern issues of formation, validity, and interpretation. Has an arbitration agreement been concluded? The very subject matter of the VisMoot problem this year. Has there been a meeting of the minds on this aspect? Is this contract valid? Which parties are bound by the arrangement? What is the scope of the arbitration agreement? That is, what disputes does it cover? All these questions shall be governed pursuant to the contract formation, contract validity, and contract interpretation rules of the substantive law that governs the arbitration agreement. In light of this, it becomes clear, or at least it should be clear to everybody, that conflict of laws is not an exotic fruit, is not something that we apply just because it is something fancy, but rather is a pivotal aspect of international business transactions and international dispute resolution. Now, because the matrix contract and the arbitration agreement are deemed separate, remember separability doctrine, it has been argued, and we can definitely argue, that different substantive laws might govern the substantive and the procedural arrangements between the parties. Even if we find them in the same instrument, because of the separability doctrine, we could have different separate laws for the two arrangements between the parties. In determining each respective law for each respective agreement, again, the conflicts rules of the forum or the special conflicts rules for arbitration, if we have an arbitral tribunal, will have to be applied. Succinctly, as Marcelo noted, it is almost universally accepted that if the parties have selected a governing law specifically for the arbitration agreement, that law will govern the arbitration agreement. That law that has been specifically selected for the arbitration agreement will govern the agreement to arbitrate. Does this happen in practice? The parties rarely give any thought to what law governs the separate arbitration agreement. This is due to the fact that at the time of contract drafting, parties simply do not appreciate the potential importance of prescribing a law specifically for the arbitration clause. It doesn't mean that we will always have multinational enterprises concluding international sale of goods contracts with lawyers that have been well-versed into the cosmos of international business transactions and arbitration, so as to know that we have the separability doctrine. We might have a small or a medium-sized enterprise that sells custom-made or bespoke, or generally speaking, furniture in large quantities, so as to have a contract that is governed by the CISG, concluding also an arbitration agreement because it is a good idea, but not being able as merchants to appreciate the difference between selecting the law that governs the matrix contract and the law that governs the arbitration agreement, because we do not have experts. And it makes sense. Or even if we have multinational enterprises, even if we have hotshot lawyers and hotshot law firms that advise the two clients in the conclusion of the business transaction, what happens is that typically dispute resolution clauses are midnight or champagne clauses. We have agreed on the commercial terms. Let's close it. You call your friend who is an associate with the litigation department and you say, hey, I'm from the contract department. This is Soterious. Please send me an arbitration agreement clause. This is what I need. And you just get a random arbitration, an arbitration clause, which is not well crafted, and it does not contain a choice of law agreement pertaining to the arbitration agreement. So these happen, and this is what will frequently happen. Even if we have the incorporation of institutional arbitration rules, again, This rarely enshrined a clause, a provision on the law governing the arbitration agreement. Model arbitration agreements do not do so, rarely do so, exception Hong Kong International Arbitration Center, for instance, and institutional arbitration rules rarely do so. Rather, most arbitration institutions encourage parties to choose a single law to govern the entire contract, the arbitration clause included. Now, problems arise from this point on. If we have an express choice of law agreement pertaining to the arbitration agreement, end of story, we couldn't care less. But the question is, absent such a choice of law clause for the arbitration agreement, what do we do? Pursuant to a popular take on the topic, the choice of law agreement covering the matrix commercial contract extends to the arbitration agreement as well. So if we have a choice of law for the matrix contract, this should extend and cover also the arbitration agreement. Doing so reflects a valid premise, albeit a premise that is somewhat incongruent with the separability doctrine, to what extent we will see very shortly. Doing so, extending the choice of law agreement for the matrix transaction to the arbitration clause should be the arbitration agreement should be governed by exactly the same law as the matrix transaction, as the one chosen for the matrix transaction, is something that we can frequently see in practice, we can frequently see in theory, unless the parties have agreed otherwise. Certainly, that could be the case when the parties have included an all-encompassing choice of law agreement in the commercial transaction that says this agreement, generally speaking, is governed by English law, is to be construed and applied on the basis of English law, a plain vanilla, let's say, choice of law agreement that could encompass also the arbitration agreement, which might have taken the form of an article, a section, or a part of the matrix contract of the international business transaction. It is reasonable to conclude that unless the parties have specifically subjected the arbitration agreement to another regime, or unless the parties have stipulated in the choice of law agreement that this choice of law agreement focuses exclusively on the business terms, unlikely scenario, the parties meant to subject the arbitration agreement to the same law with the main contract. And this was the decade-long legacy of the Sul-America judgment by the English court in 2012 that Marcelo has very eloquently presented to us today. He made a very clear presentation of the case, so I'm not going to discuss about, present again the merits of the case, the facts of the case, and what was the holding. But generally speaking, in Sul-America, to repeat what Marcelo has noted, the court rules that the proper law of an arbitration agreement is determined under established common law choice of law rules. The court must defer to the party's choice of the proper law, that is one, whether it is express or implied, and failing this express or implied selection of the law governing the arbitration agreement, then we apply the legal system with the closest and most real connection to the arbitration agreement. Again, we have party autonomy, express or implicit selection that crosses to the arbitration agreement, or that we have directly for the arbitration agreement. Absent that, classic rule, classic connecting factor in private international law, closest and most real connection. The law of the jurisdiction of the legal order with the closest and most real connection will apply. And that would normally be the law chosen to govern the commercial contract, which as a result should also govern the arbitration agreement. This is what the parties seem to have meant. The commercial transaction seems to be linked solidly, rigidly, strongly with a particular jurisdiction. It makes only sense that we extend this link also to the dispute resolution clause for our business deal. This approach fosters legal certainty. It streamlines the agreements between the parties, procedural and substantive. It amplifies party autonomy and minimizes the complexity in dealings. We have just one choice of law agreement for both transactions for the entire deal. This extension of the general, if you will, the general, let's put it this way, choice of law agreement to the arbitration agreement could be considered as either an express selection of the law governing the arbitration agreement, as was ruled in the Kababji case in 2020, as an express selection of the law governing the arbitration agreement too, excuse me, particularly if we have an all-encompassing language, so again, construction of the contract, or an implicit selection of the law applicable to the dispute resolution clause, as we have seen in the BCY case in Singapore from 2017. So either express selection or implicit selection. As noted, however, the separability doctrine raises obstacles in readily extending the choice of law agreement for one contract to the other, or the choice of law contract for the matrix transaction to the procedural agreement between the parties. Indeed, under a light or under a narrow reading of separability, the doctrine applies only in the event of validity issues pertaining to the commercial contract or the dispute resolution clause. It does not completely sever the two agreements. The two agreements are inseparably linked. They both point to one business deal. And they might happen to be even in the very same instrument, the very same document. Under such a light, under such a narrow interpretation of separability, the arbitration agreement and the commercial contract can be viewed as one for the purposes of determining the respective governing law. They are not completely dissociated from one another, but this dissociation pertains only to the validity or invalidity issues of the two arrangements. A more rigid and expansive reading of the doctrine points to the complete separation of the arbitration agreement from the commercial contract, as allowing the possibility of the arbitration agreement being governed by a law different from the law governing the commercial contract. And classic situation here, and most prominently, that could be the law of the seat, as noted in Article 5(1)(a) of the New York Convention. Indeed, 8 years after the Sulamerica case, we have the English court in NCACHAB that changed course and ruled that absent an express agreement between the parties regarding the law governing the arbitration agreement, there is strong presumption that the arbitration agreement is governed not by the law chosen in the matrix contract, but by the law of the arbitral tribunal's seat. Specifically, the court noted that it is a matter of construction whether we have a general choice of law agreement that covers the arbitration agreement too. If we have an all-encompassing, a general choice of law agreement that covers both transactions, procedural and substantive, no further inquiry is required. If it does not, then a presumption in favor of an implicit choice of the law of the tribunal's seat will kick in. Granted, we need to be very careful when we have this kind of legal fictions, of legal interpretations, let's say. Why? Because we need to be very careful to not impute a choice of law agreement when there is no such conflicts arrangements, when there is no such choice of law arrangement with regard to the arbitration agreement between the parties. And this principle is not, again, unique to arbitration. This principle has been enshrined already in private international law and in leading private international law instruments such as the Rome I regulation, as well as in the 2015 Hague Principles on Choice of Law in International Commercial Contracts. Neither applies to arbitration agreements, but we can see that we have a general principle of the law pertaining to implicit choice of law agreements. And this general principle requires a real, albeit implicit, albeit tacit, but a real choice by the parties. Perhaps this could be the doctrinal link that could balance Sulamerica, Kababji, and the ENCA judgments. The question of whether there was an express or implicit agreement between the parties versus the lack of a choice of law agreement for the arbitration agreement altogether. If there is one, that could very well be the same with the law selected for the matrix contract. If we can find that there was an express or an implied agreement there, then we can have the same choice of law agreement for the matrix contract and and the arbitration agreement. Absent such a choice of law, however, and as Marcelo has noted with regard to the practicality of looking at the enforcement, the recognition and enforcement of the final arbitral award, because we could not care about the award that much if we cannot take it, hold it, and then finally enforce it. It is not just that we go to arbitration to get a paper that writes on it, arbitral award, and you win. You might want to enforce it. So absent such a choice of law agreement between the parties that we can find either express or a clear but implicit, it might be better to align with the rules set forth in Article 5.1a of the New York Convention and the law of the seat. To conclude this short presentation on the law governing the arbitration agreement, to allow for further discussion, as also noted by commentators, a close examination of the case law in determining the proper law of an arbitration agreement really reveals a strong tension between the need to give effect to party autonomy on choice of law, on the one hand, so party autonomy, and broader policies regarding the regulation and promotion of arbitration, which are especially acute in major arbitration centers, such as England and Wales. And we have seen that clearly in the SulAmérica case, and then with the NCACHAP case, where we have policies being advanced through case law, pro-arbitration policies through case law to the benefit of the particular arbitration centers. Hence, as we anticipate the review of the NCACHAP case and what is going to happen, meaning what is going to happen later on in case law, prompted by this line of at least these three English cases which have influenced the entire arbitration cosmos, it might be preferable for courts to not easily impute an implicit agreement of the parties. Courts and tribunals cannot decide for the parties if the parties have not decided themselves about what law governs the arbitration agreement. Rather, as already suggested, absent an express or a clear implicit choice of law pertaining to the arbitration agreement, absent an express agreement on the law governing the arbitration agreement or clear intent to extend the general choice of law agreement in the matrix commercial contract to the dispute resolution clause, adjudicatory authorities, arbitral tribunals, courts shall focus on the conflicts rules enshrined in the Magna Carta of International Arbitration. They should focus on the application of Article 5 of the New York Convention, which fixes a clear and common point of reference that leads to the application of nothing else other than the law of the seat of the arbitral tribunal. So I tried to balance the law governing the arbitration agreement with the law governing the matrix contract and the need to have an enforceable arbitral award. I do not know whether I have succeeded in doing so, or at least I hope that I have put some items on the table for further discussion. Again, thanks a lot for the kind invitation and thanks a lot for your attention.
Dr. Soterious, once again, thank you very much for accepting our invitation and for the excellent class you just gave. Thank you very much. And last but not least, I will turn the floor over to Dr. Fillers, who is an assistant professor at the Riga Graduate School of Law, Latvia. Dr. Fillers, the floor is all yours.
Thank you. First of all, thank you for inviting me, for giving me this option to participate in this very interesting and I think quite original event where academic topics, practical topics are connected with the VisMoot. I find it really challenging and exciting. Now, I have seen so far that I think we have had some different approaches as to our task, with some speakers more focusing on the Vis problem and using it as a framework, while others more, I think, on the topic in a more abstract way. I must say that since I'm doing presentation on the topic where I've written an article a few years ago, then I, of course, to a large degree, will follow very much the same ideas, partially because they have not really changed that much from the time when it was published. So it will be somewhat mixed. I think mostly I will be looking at it from a more abstract point of view, and if there will be time, I will try to say a few words about some differences in this specific case, which I think are relevant, which were not really very much considered in my article. As to the question whether I give arguments to the parties, in some sense, yes, I think I will be working around the arguments, but at the same time, since they are publicly available, they can be easily read, not only in my article, obviously, but also in those of other scholars. Then I think there is nothing really, no confidential stuff there that the participants of the VisMoot should not know and don't know. Probably they know already. I can only try a little bit to maybe emphasize certain points. Okay, so the topic is application of the CIG to arbitration agreements. The question has lots of different aspects and subdivisions, and I think the question as it is looked at in academic literature is a bit broader than what is really relevant for this year moot. Because to a large degree, the discussion is very much focused on the question of formal validity, whether the liberal form requirements in the CIG have impact on the usually more strict form requirements of the arbitration agreement. And that is usually the crucial topic, and other things are built around that, are seen. This is a main battlefield in the debate. I think from our case, this becomes somewhat less important than those things that usually are seen as secondary. But I will try to look at a little bit on both of those sides, even if something is probably less relevant for this year problem. At the same time, I will try now also to address some arguments. And of course, if you think about the arguments of what should be analyzed in trying to understand whether TSG convention that obviously is on its face value, based on its text, is not about arbitration. It's about the sale contract, substantive law, substantive contract. Then there are certain, of course, arguments that come up and that I think are usually played with and played around. One of them is, well, I would start by the first, maybe, which is a bit something that was already, I think, a little bit said in a different context before, is, of course, there's a difference whether parties have chosen something explicitly or not. And already it was stated that it's very rare that parties choose explicitly law applicable to the arbitration agreement. This is not typical in practice, although I think it is mentioned in most arbitration law manuals and textbooks. Somehow this information doesn't pass on to the ones who draft contracts. And of course, if the CIG is explicitly chosen as a law applicable to arbitration, which, as far as I remember, when I was writing an article, some authors said was a situation that has never existed. Of course, nobody knows all the contracts, but never witnessed, really. Then probably, especially in arbitration, which is, I think, quite liberal to the questions of law applicable, and really very often bases its opinion on its decisions on what the parties have agreed upon, more so sometimes than maybe national courts, which might have some more restricted approach to that. Then probably the parties have said, we have agreed that CIG applies to the validity, formation, enforcement, etc. of arbitration agreement. Then probably the arbitration tribunal, to the degree possible, would apply the CIG. Of course, now when I said validity, it's important to mention that, of course, CIG itself doesn't talk about substantive validity. So there you can't do anything really, because it just doesn't really have that much of regime there. But formation is covered by the CIG. So this is one situation, but it's kind of a hypothetical situation because it doesn't often happen. So what I've been more interested in, especially when I was writing an article, was whether objectively it was meant, or it can be interpreted that CISG is applicable, whether it was meant originally or not, but that from the text of the CISG, from its system, from its purposes, you can derive that it, if I may use this term, wants to apply to the arbitration agreement. So I will be talking more about this objective aspect rather than subjective, rather than the situation when the parties themselves have expressly stated that they want the CISG to apply. When approaching this topic, I personally think that, of course, important argument to begin with in this game is a separability, obviously. People would argue whether separability basically saying like requires that arbitration agreement is governed by different law, and substantive contract, well, then can be governed by the CISG. Now, I personally think that it's not a very good approach. That's my opinion. I think that there is a counter argument. We already heard in the previous presentations that separability itself is understood in different ways. And separability can be really, you can really focus on the question that invalidity of the main contract does not mean that an arbitration tribunal has to say we can't do anything, we can't hear the case, and we can't decide that it's invalid. Or a much broader approach saying, well, it also implies that there are different laws applicable to arbitration agreements and the main contract, which again doesn't necessarily say that they must be different laws applicable, which I think is still a bit different. Saying that it can be or it must be, these are different stories. So again, whether that argument is very persuasive per se is also the question. However, I would look at it a bit different because I approach, especially my article approach was, as I was focusing most on the courts and how they would apply the CISG, then I looked at it from the perspective that CISG is an international convention. Thus, it's a CISG that determines when it wants to apply and what is its scope. And if there is a separability somewhere there, and well, it probably is somewhat derived from the New York Convention, it often is derived from national laws, still it would seem to me that CISG is the one, it's a starting point. And for me, the analysis would start with the question, does CISG know that there is a separability principle that prevents it from applying to arbitration agreement? So separability per se for me would not sound a very persuasive argument, because I would ask, shouldn't we look at what international convention itself thinks about it? And if it says no, we consider, I as a convention consider that I'm applicable to the arbitration agreement, then the fact that there is separability somewhere outside, which probably does not require anyways that different laws apply to arbitration agreement and the main contract, give it an option, but doesn't require that, then I don't see how separability can really do anything in that respect, if the CISG itself does not align with it. Now, the question whether it aligns or not is a question of interpretation of the CISG. And the arguments could be, I think, different. And they can be found very much in the scholarly works, where I've myself seen at least three approaches. So full applicability of the CISG, partial, and full rejection. So three boxes. Professor Walker, I think, in one of her articles somewhere in early 2000s, was and probably is still the absolutely seminal important text which everybody mentions. And this is text, I think, especially in the beginning, because it was somewhat thought-provoking. And it really says CISG has full application to the arbitration agreement. So basically, the word full here means specifically the form requirement. And the whole argument is basically built around the form. It is what can be described as a teleological argument, saying it makes no sense to have free form for the main contract, which can be for millions and billions, theoretically for billions of dollars, euros, or whatever, but it's unlimited what it can be about. Sale contract, whatever its size, is not defined anywhere. And at the same time, be subordinated to the strict form requirements for arbitration agreement. And this would be her main argument. It is just not right. It's not how it should be. There is a problem with the logic. So this justifies application of the CISG in total. So form, conclusion, interpretation, termination agreements, avoidance agreements found in CISG, all of that would apply to arbitration agreement. And of course, additional argument in this Articles 1981 of the CIG that mentioned dispute resolution clauses, thus giving the reason to say that authors of the CIG wanted it to apply to arbitration agreements. So that is, again, just as an argument, that article and some articles that are, I think, referring to it later, they try to justify that CIG in total applies to arbitration agreement. There are some authors, although I think that when I started my article, I thought there will be many. At the end of the day, there seem not so many that say there is absolutely no connection really. CIG does not apply to arbitration agreement, partially because, of course, it refers in the first of its articles to the sale contract. So the wording seems to imply doesn't want to apply to arbitration agreement, as it's not a sale contract. And so it's absolutely, these are two circles that do not overlap. They are staying one on the one side, another on the other side. And these authors would then try to explain what does it mean, Articles 19 and 81. And I think it's somewhat possible to explain. It's to say that basically these articles are, again, drawing kind of lines how much, for example, Article 19 would just say that anything that is inserted, in principle, inserted in the reply to the offer, if it means that something else is added or some kind of the terms are changed, of course, there will be no contract, but it has nothing to say about the arbitration agreement itself and even how it's concluded. CIG doesn't say what needs to be an offer and acceptance for arbitration agreement to be concluded. It says that if arbitration agreement is, for example, added in the reply to offer, then there is no contract of sale. And theoretically, there still could be an arbitration agreement, as formation of the arbitration agreement would be governed by absolutely different law, nothing to do with CIG. And then Article 81 would have the same thing the other way around. It would just simply say that avoidance of the sale contract under the CIG doesn't automatically lead to consequences for the arbitration agreement, but maybe there is other law that applies to arbitration agreement and it has these consequences. It's simply not the CIG. Let me say honestly, I find it a bit artificial, complicated to apply, but there could be such argument. And then I think the majority school goes for somewhat middle of the road approach, saying that, well, probably the CIG applies to the conclusion. Article 19 is one of the evidences of that. Probably it applies to interpretation. This has also been my opinion. So if it applies to the formation of the contract, I don't see why it would not apply, for example, to interpretation of the arbitration agreement. But it should not apply to formal validity, and it should not apply to things like enforcement of the contract, for the reason that CIG seems so non-suitable for that. It seems so much really about the sale in its parts dealing with the rights and obligations of the parties, that it doesn't sound that these articles are meant to really deal with arbitration agreement. So basically only the formation part could be of relevance. I must say, honestly, if I put these arguments together, then I think that there is one argument that I find quite strong, and I agree with. It's about the form. Because if we look through the history of the CIG, personally, I have not, maybe somebody has found something, I have not found even one word during the negotiations process of the CIG where very distinguished scholars, private international scholars who should have seen these problems have ever posed a question. So what we are doing now, would it have impact on the form of arbitration agreements? And even more so, would it have an effect on the choice of court clauses? Because basically these are like twins, and pretty much the same should be then the same situation for arbitration agreements and choice of court clauses. This is particularly strange because, if I'm not mistaken, hopefully I'm not, by that point in Europe already there was the Brussels Convention, which had, this is a convention on jurisdictional rules for courts, which had its own rules on how choice of court clauses are concluded. So if these people that were negotiating the convention, they had a thought that these will be implications of Article 11 of the convention, the formal freedom, etc., I can't imagine why they would not have raised it and indicated that there is a problem. Moreover, the derogation from the freedom of form seemingly was made, possibility for countries to derogate from that, in mind with the socialist countries' regulation, laws on formal requirements for sale contracts. Again, nobody thought on how it will work with arbitration agreements, how it will work with choice of court clauses. So I think this indicates that the form was not what they meant to regulate form of these contracts for sure. Moreover, there are also some statements during the negotiations that the authors of the convention did not intend to have any influence, on the jurisdictional rules. Again, we can understand differently. What does it mean? Influence on jurisdictional rules, but probably this formal requirement is so significant for choice of court and arbitration agreements that hard to imagine that they really wanted it to have such effects but didn't address it. So, but these are, of course, open arguments, and you can argue around it. And if there is really just a silence among authors of the CIG, at least from what I have been able to identify, nobody expressly talked about it can mean many things, or it can be interpreted in different ways. So again, as I said before, I would personally probably see, but this is just my opinion, it can obviously, again, there are different arguments, that CIG probably applies to formation of the arbitration agreement and its interpretation, while I'm not so sure about other things, specifically about the form. This also seems to be somewhat reflected in a case law where many courts and tribunals, when discussing standard terms, whether they are incorporated into the contract, even when the question has been that the standard terms of arbitration agreements or choice of court clauses have applied CIG and have not really even posed the question that there is something strange here, something that needs to be addressed in some more express, maybe kind of academic manner, weighing arguments. But it seems that the formal validity, for example, has been a more rare issue to be addressed by courts, so that they would say that CIG applies to the form. So it would seem to me that there is some ground to say formation, interpretation of arbitration agreements, when they are closely connected, of course, with the main contract. Because if it's really that sale contract has been concluded, dispute arose, parties agreed then to arbitration, then unfortunately it sounds very unlikely that CIG would apply. But of course, this division line is also problematic. So there could be different scenarios how, as we see in our VisMoot case, there is a bit of more complicated, this incorporation of arbitration clause into the contract. But when it's really separated, absolutely separated, then probably you would have some problems with finding arguments that CIG applies. The last points I would like to mention is that, as I said, my article was basically very much built around the courts. Why? Because I am following from the proposition that courts that are parties to the CIG are really bound by the convention. Now, if you are doing the Vis problem, you might use an argument that all of that is really not relevant because arbitration tribunal is seemingly not bound by the CIG, as some consider in principle. Some would say it's an arbitration tribunal, it's not a court, it's not bound in any way. So then it applies what it considers appropriate. And then it's a question whether these arguments have the same force to begin with. And if I get not mistaken, in our case, the tribunal is seated in a country which is not a party to the CIG. Again, I hope I'm not mistaking that. If it's so, then this makes it even more complicated because, again, my arguments have been always built around this objective applicability of the CIG, which is relevant to the adjudicatory body that is bound by the convention. If it's an arbitration agreement, that is arbitration tribunal, which in principle seems not to be very much bound by CIG and has much broader freedom in deciding what ought to apply to main contract to arbitration agreement, etc., then this is some weak point in the whole reasoning here. If it's even more so in a country that in principle is not a party to CIG, then the argument becomes even weaker. And then, of course, it requires some further development of these arguments or their adaptation for a bit different case. And I don't know, even from my own perspective, what should be really the kind of firmly right answer here, because I think even this simple case with the court, which is bound by the CIG, it's not so simple, not so easy to resolve. Here, when you have additional complexity, I think the space for arguments becomes much broader. And maybe, and I will finish on that, everything that I say or everything that was written by me in the article and by others on whom I based my reasoning has little merit, because there are these other arguments saying, well, we are an arbitration tribunal. We're not in a CIG member state. All these arguments, they are not very much relevant for us. And tribunal has lots of freedom to decide, maybe on the basis of some other principles and arguments. So this was my attempt to somewhat draw or emphasize some of the arguments that could be used in principle in this discussion about application of CIG arbitration agreement, and hopefully to some degree also relevant to this year's VisMoot problem. I think my time is also up, so thank you for your attention. I think that's all on my part.
Dr. Fillers, congratulations on the class, and thanks again for accepting our invitation. And so now, due to the excellent and complete presentations and not to go over the time, we will leave any questions from the audience to be answered at a later time. And on behalf of the CJA, CBMA, I would like to thank all the speakers that accepted our invitation and took the time out of their schedules to be with us at this moment. And we also thank you very much for everyone who attended. And we hope that we have contributed to the students. And before I finish it, I don't know if the speakers would like to complement anything, or can I just end the presentation?
I would like to compliment, not to compliment, to compliment. Congratulations to all. Very interesting presentations.
Exactly.
Thank you.
Thank you.
I second that.
Thank you very much. So before I finish, I would just like to remind the public that tonight we will have another panel on oral advocacy at 8 p.m. São Paulo time. And we are waiting for you. Thank you very much. Bye-bye. See you.
Thank you, everyone.
Thank you.